Good evening. My name is Kenneth Jang, and I will address why Section 203, 206, 215, and 213 should remain the same in the Patriot Act. The truth is, as Viet Dinh, a professor of law, remarks, the Department of Justice concluded that its job in securing the safety of America and her people in the years since September 11th would have been much more difficult, if not impossibly so, without the USA Patriot Act. In particular, the safety of America would be called into jeopardy if these sections, which are information sharing, roving wiretaps, access to records, and sneak and peek warrants, were amended and or abolished. I will now go into why these sections are necessary and do not need any adaptations. In dealing with Section 203, information sharing, which is a necessity for investigations and does not invade privacy due to the restrictions that are placed upon this information sharing. A perfect example of how this is a beneficial tool for investigators is the Lackawanna 6 cases. Due to the restrictions before the Patriot Act, it was required to have 2 investigations. Neither were able to fully investigate the issue because one was for drug crimes and the other one was for terrorism. However, with the enactment of the Patriot Act, Section 203 gave the officials enough information to persuade 5 of the 6 criminals to admit to providing material support to Al-Qaeda, and the 6th admitted to illegal transactions with the Al-Qaeda. However, not all restrictions were lifted from information sharing. In fact, according to Viet Dinh, more restrictions were placed, leading to the use of grand jury information, which weighs the need for secrecy in proceedings with the protection of the citizenry from attack. Additionally, he states that Section 203 of the Act expressly limits disclosure to foreign intelligence information, only foreign intelligence information. The Act defines this foreign intelligence to include information relating to the ability of the United States to defend itself against terrorism, sabotage, and clandestine intelligence activities of a foreign power. With protections such as these, it is clear that the privacy of the citizens is highly protected. For these reasons, Section 203 need not be amended because it is necessary and fair to allow information sharing. If the affirmative plan is enacted to abolish Section 206, which is roving surveillance, it will completely block intelligence from countering terrorism. The opposing advocate, Alberto, argues that wiretapping can and has been used for other crimes instead of terrorist activities and can wrongly tap innocent people. I would like to bring up the fact that wiretaps listens for specific words as well as phrases and has been used for other crimes, such as drugs, because it was already in place before the Patriot Act. Additionally, Rosenzweig, who's a professor of law, states that a minimization requirement mandates that the termination of surveillance must occur upon the determination that the intercepted conversation is innocent. With this law in effect, it is evident that upon evidence of innocence, the surveillance will be terminated. He then goes to say that, to begin with, the statute has substantial safeguards against misconduct already. No interception may be authorized unless there is probable cause to believe the target of the surveillance is a foreign power or an agent of a foreign power. Therefore, to even be wiretapped at all, one would have to seem suspect. Even if critics say that there is a lacking of a checks and balance system, there is administrative and judicial scrutiny prior to the authorization, which keeps this system in balance. Evidently, removal of Section 206 would be counterintuitive and is unnecessary. Once again, with Section 215, the affirmative would like to make you believe that it lacks the protections to stop abuse when accessing records. However, as affirmed by U.S. Attorney and former federal Judge Ryan and an attorney, McCarthy, this law is nothing new, and it has been done for years through grand jury subpoenas. In fact, 215 provides additional protections, notably requiring a federal judge, once again, to approve every request in advance. This provision cannot be used to investigate ordinary crimes or even domestic terrorism. As Ryan continues, 215 bars investigating any citizens for exercising First Amendment rights, so there is evidently a protected and proper protocol for accessing these records. McCarthy elaborates on this by discussing that Section 215 prudently charges Congress with the responsibility of ensuring that the executive branch does not abuse this authority. With the implementation of Section 215, rest assured that every measure is being taken to assure justice, equality, and privacy, so there is no need to amend this section. The proponents of abolishing Section 213 would also argue that it violates the Fourth Amendment. However, these sneak and peek warrants are only used when there is very probable cause for the search, and it follows all laws. These sneak and peek warrants have often been used in the past for drug crimes as well, which is why there's about 65% of the cases for sneak and peek warrants being drug cases. Clearly, these warrants would not be issued with a delayed notice unless the judge allows it, because once again, the judge must give permission before the warrant is issued. Ryan affirms that 213 requires investigators to demonstrate to this judge that the delayed notice is necessary to prevent destruction of evidence, fleeing of a criminal suspect, or compromise of an ongoing investigation. And he also states that these searches have been standard law enforcement practices for years. With the checks and balances of having judges check these investigators and the necessity of temporary secrecy for preemptive investigations, clearly Section 213 is the perfect solution and need not be abolished. As I stated, and as Josh has stated, these checks and balances make it so that there's a requirement to receive judge approval, not just the Attorney General, as Alex has stated. Therefore, there is no need to make adaptations of these sections. Thank you.